The Supreme Court's ruling in favor of Marlean Ames, an Ohio woman who filed a reverse discrimination lawsuit against her employer, marks a significant shift in employment discrimination law. The unanimous decision, authored by Justice Ketanji Brown Jackson, removes the background circumstances requirement that previously made it harder for majority group plaintiffs, such as white, straight, or male individuals, to bring discrimination claims. Ames, a straight woman, argued that she was denied a promotion and later demoted in favor of LGBTQ employees, claiming that diversity, equity, and inclusion (DEI) policies unfairly disadvantaged her. The court's decision simplifies the legal standard for reverse discrimination claims, making it easier for members of majority groups to allege discrimination. This ruling has major implications for workplaces, particularly those with strong DEI initiatives. Legal experts predict an uptick in lawsuits from individuals who feel that diversity efforts have unfairly hindered their career advancement. Some argue that the decision ensures fairness for all employees, while others worry that it could undermine protections for historically marginalized groups. Let us recall that Marlean Ames began her career in Ohio's state government in 2004 and steadily advanced within the Department of Youth Services. In 2017, she found herself reporting to a gay supervisor and alleges that she was denied a promotion, which instead went to another gay woman. Ames challenged a legal requirement enforced in 5 appeals courts across the country. This rule mandates that plaintiffs from majority groups, such as white, straight, or male individuals, must demonstrate background circumstances to support their discrimination claims. To meet this standard, plaintiffs typically provide statistical evidence showing a pattern of bias against majority group employees. Ames was unable to present such evidence, leading to her case being dismissed in the lower courts. During oral arguments in late February, the Supreme Court justices appeared broadly supportive of Marlean Ames' case. The discussion centered on the background circumstances requirement, which had been applied by the Cincinnati-based 6th U.S. Circuit Court of Appeals and several other federal appeals courts, including those in Denver, St. Louis, Chicago, and Washington, D.C. The requirement imposed a higher burden on majority group plaintiffs, forcing them to provide additional evidence, such as statistical data, demonstrating a pattern of discrimination against their group. The justices, both conservative and liberal, seemed to agree that this standard was unfair and inconsistent with broader anti-discrimination laws too. At a time when workplace diversity efforts have become a politically charged issue, the Supreme Court's conservative and liberal justices, along with the attorneys involved, largely agreed that the Sixth Circuit's analysis was flawed. The case reached the Supreme Court last fall, shortly before Donald Trump was elected, on a platform that included restricting diversity, equity, and inclusion (DEI) initiatives in both government and private sectors. His administration has since taken steps to cut funding to organizations accused of supporting DEI efforts, though many of these actions are currently under judicial review. Despite the broader political debate, Ames' case was primarily procedural rather than ideological. Interestingly, both the Trump and Biden administrations agreed that the Sixth Circuit should reconsider its approach to reverse discrimination claims. Now the big question remains: how will businesses and policymakers respond? Will this ruling empower employees across all backgrounds to challenge workplace bias, or will it pose new legal challenges for DEI initiatives? The implications could be profound for hiring and promotion practices nationwide. Join the discussion. Share your thoughts and reactions in the comments below, and subscribe to my YouTube channel for more in-depth analysis on global legal trends and workplace equality. Let's dive deeper into what this ruling means for all of us.